let's get started. Today we're going to present to you on UK sanctions on Russia and how that's impacted in particular on the energy sector. I'm a partner in Brodie's specialising in sanctions within our corporate crime team, and my colleague Lisa Kinroy is an associate in the team. Lisa and I have spent much of the last 6 months advising clients in the energy sector on the impact of Russia sanctions. Before we agreed with the team to present to you today, we thought about what would be the most valuable thing that we could give you. And we thought what would be useful would be for us to talk about the types of issues that we've seen and we've advised clients on in recent months. So we're going to try and make this session as practical as possible. We know that sanctions is in the news every day, and indeed today we've seen the decision for the Nord Stream 1 pipeline to be turned off. So we know it's very much in the news. So what we wanted to try and do was give you our practical experience of what issues we've been helping clients with. So what we'll cover then is, yes, the impacts of sanctions on the sector. We'll also look at, in brief terms, how the UK sanctions regime came into existence in the first place. We'll then go into those common issues and themes that we're seeing, and we'll finish with some practical compliance steps. So then turning to look at the impact on the sector, this is really just a headline for what we'll come into later on. The categories of key sanctions issues we're looking at with clients: financial sanctions. So this is the risk of breaches because a business is dealing with someone who's a designated person, or it's dealing with a business which is owned or controlled by a designated person, and we'll explain that concept in more detail. And the other main category is trade sanctions, and that is looking at potential risks from exporting or supplying prohibited goods from or to Russia, or sourcing prohibited goods which come from Russia in the first place. So financial and trade sanctions have been the two areas that Lisa and I and the team have been very much focused on. Some of the common compliance actions that we've seen clients take to meet these risks are, first of all, reviewing relationships with counterparties and supply chain, also reviewing the sources of goods and materials, and in some cases, taking decisions to terminate existing contracts and projects because otherwise there would be a risk of a sanctions breach. Now, I think you'll all be familiar with this, the background to the rationale for sanctions, but we'll touch on this for a moment. Sanctions are in place to achieve outcomes, to achieve purposes, and they're often imposed by a range of organisations or governments and organisations. So yes, the UK will impose sanctions, the EU will impose sanctions, the US will impose sanctions, and also the UN and others. Some of the examples, well, yes, Ukraine is an obvious example where the purpose of sanctions on Russia is to halt destabilizing behavior. The Iran sanctions were introduced to achieve a policy goal of moving away from the nuclear weapons program. And again, other examples of sanctions being used, for example, to stop, halt, and improve human rights conditions in countries such as Myanmar. So there's always a goal or a purpose behind them. It's worth bearing that in mind when we're looking at the compliance steps that need to be taken. So looking to our focus today, we are going to focus on the UK sanctions regime in relation to Russia, because that's very much in everyone's thoughts. But I should remind everyone that there's a whole range of sanctions regimes in place, both UK regimes against other jurisdictions or other countries, but also other governments, organisations applying sanctions which are also often relevant to clients. So while we're looking at the UK only here today, we tend to find that for the majority of our energy clients, it would necessarily not just look at UK sanctions, but also EU sanctions and US sanctions regimes to have a complete compliance package there. So I wanted to give you that warning at the outset here. Okay, with that, I'm going to pass things to Lisa, who's going to start with giving us that platform of how the UK sanctions regime came into place. Lisa.
Thanks, Paul, and good morning, everyone. So as Paul mentioned, in the next couple of slides, we're going to give a brief overview of the structure of UK sanctions law. I think as a starting point, it's fair to say that the UK sanctions regime is very much derived from the EU sanctions regime, and post-Brexit, the starting point for the law in the UK on sanctions is the Sanctions and Anti-Money Laundering Act 2018, or SAMLA. This is the umbrella legislation which provides the framework for country-specific regimes. SAMLA also provides us with the designated person concept, which of course will be very familiar to everyone on the call. A designated person is a person who is listed on the UK financial sanctions list as being subject to UK financial sanctions. Designated persons can be either natural persons or legal persons, and we'll talk about the designated person concept in a bit more detail shortly. But what I would say just now is that we've linked there on the slide a link to the current homepage for the UK financial sanctions list, which will be a helpful resource hopefully to everyone. I'd also note that through that link you can sign up for alerts where there are any additions or changes to the UK financial sanctions list, which is a helpful prompt given the almost daily changes that we're seeing to the list. As a final point on this slide, I just mentioned that when there's a requirement under SAMLA for when a minister is implementing a specific sanctions regime, that requires to be accompanied by guidance, and there's very helpful guidance available at the link that we've provided there on the slide. So turning to look at the UK sanctions regime in relation to Russia, that is contained in the Russia Sanctions EU Exit Regulations of 2019. Amongst other things, the 2019 regulations impose financial sanctions prohibitions. So when we talk about financial sanctions prohibitions, we're thinking about dealings with designated persons. In addition, they impose trade sanctions prohibitions, and in relation to trade sanctions prohibitions, we're thinking about the import, export, supply, and trading of goods and the carrying out of certain activities in Russia. So if we move on to look at financial sanctions in a little bit more detail, on the slide, we've summarised the key financial sanctions prohibitions which are contained in the 2019 regulations. And as you'll see, they impose an asset freeze on designated persons, which prohibits any dealing with funds or economic resources owned, held, or controlled by a designated person. There's also a prohibition on making funds or economic resources available directly or indirectly to a designated person, and a prohibition on making funds or economic resources available for the benefit of a designated person. So as you'll see, the wording of the prohibitions is broad and effectively rules out any form of dealing with a designated person. It's important to note that the prohibitions apply not just to dealings with designated persons, but also to legal entities which are owned and controlled by designated persons. And this means that it's important to be clear about the legal interests which sit behind a corporate entity in order to rule out the risk that that entity may be owned or controlled by a designated person if it's not itself a designated person. In terms of understanding whether or not a corporate entity is owned or controlled by a designated person, we've set out on the slide the tests for determining whether a person, such a corporate entity, is owned or controlled by a designated person. And the tests are set into two conditions as follows. For ownership, the threshold is 50% shareholding. For control, the threshold is 50% of the voting rights or the ability to appoint or remove a majority of the board of directors, or otherwise a general ability to control the affairs of the business. I'm going to pass back to Paul now, who's going to highlight how we've seen some of these issues arising for clients in practice.
Thanks, Lisa. So, yeah, as we said at the outset, what we've tried to do here is give you a flavour for some of the issues that clients have been seeing. So take the law and then apply it to real circumstances. So the first looking at here is counterparties. So the situation we've seen in a number of cases now is a counterparty for a client, and that counterparty is ultimately owned by a Russian parent company, which has Russian board members. And clearly, we see in here Russia there, we start to think about, do the financial sanctions apply? Is there a concern here? So the question we've dealt with on a number of occasions now is, do ongoing dealings with that counterparty, with the Russian connection in the background, does that present a UK sanctions risk? So Lisa, can you take the audience through what are the issues we've considered in those circumstances?
So the key issue here is to understand whether the counterparty is owned or controlled by a designated person. I think that the starting point for us would be to identify if the Russian parent as an entity is a designated person. Thereafter, we'd be looking to see whether there are any members of the board of the Russian parent who are designated persons. I think in the situations we've seen, Paul, for clients over the last few months, it's quite common to have a situation where the parent company is not designated, but there's a member of the board of directors who's designated as an individual. In that scenario, assuming that member of the board is not also a shareholder, the key thing we'd be looking to understand is whether that board member meets the control threshold, so whether they have the 50% voting rights or the ability to appoint or remove a majority of the board of directors, or otherwise a general ability to control the affairs of the company.
Great, that's really helpful. So I think we move on, Lisa, to joint ventures.
Yes, so another key financial sanction prohibition which we're seeing regularly cropping up with clients is a prohibition on establishing a joint venture with a person connected with Russia. This is one of the more recent amendments to the UK's regime in relation to Russia, so we don't yet see this prohibition in financial sanctions in relation to other target countries. At this point, it's Russia that we're concerned with. And in order to understand whether this prohibition applies, we'd need to look at the proposed joint venture partner to understand whether it's connected with Russia. We've set out the tests on the slide there, but it's important to note the wording of the prohibition, because it prohibits both the direct and the indirect establishment of any joint venture with a person connected with Russia. We'd need to be looking both at the joint venture partner as an entity, as well as the shareholders and senior managers of the joint venture partner as individuals. And Paul, I think we're going to move on to an example to just explain how this might arise in practice.
That's right. And of course, for energy clients, the energy sector, joint ventures and how joint ventures can be operated has been absolutely fundamental in the last few months. So again, the issue we've seen here is proposed JV partner, and that partner is a company with links to Russian state officials. So perhaps it may or may not be a company which is incorporated or based in Russia, but it certainly has links to Russian officials. And Lisa, the issue we've had to look at there is, does proceeding with that JV, with that proposed partner, how does that create a risk of non-compliance with UK sanctions?
Sure. So as with our previous examples, the starting point is to understand if the proposed joint venture partner is a designated person. Again, if it's not a designated person as an entity, we need to understand if it's owned or controlled by a designated person. And that means we'd be looking at the shareholders in the joint venture and any superior entities in the group structure to understand if they are designated persons and if the ownership and control tests are met. Again, we'd also need to understand if any of the directors or senior management of the proposed joint venture partner are designated persons as individuals, and if so, in respect, whether any of the control tests are met in respect of them. Once we've completed that aspect, we can move on to consider the joint venture prohibition itself. And that means we need to understand if the joint venture partner as an entity is connected with Russia. So that means, is it incorporated or constituted under the law of Russia or domiciled in Russia? We'd also need to consider whether any of the directors or senior management are as individuals connected with Russia. So the question there is whether they are ordinarily resident or located in Russia.
Great. And we move on to trade sanctions, Lisa.
Yes, so in addition to the financial sanctions prohibitions, which we've just discussed, the 2019 regulations impose certain prohibitions in relation to trade with Russia. Trade sanctions can restrict exports and imports of certain categories of goods, and they can restrict the supply of those goods from Russia to a third country. So the reach of the trade sanctions is potentially very broad. Trade sanctions are based on specific categories of goods, and we've listed the principal goods categories on the slide. And if we move on, we're going to take energy-related goods as an example. So moving on to look at energy-related goods. As an example, we've taken one of the prohibitions in relation to energy-related goods, which is contained in Regulation 44, and that prohibits the export of energy-related goods to or for use in Russia. And Paul, on the slide there, we've got an example of how this can arise in practice.
Yeah, again, yes, we've tried to take a real scenario here. So thinking about energy-related goods, thinking about that being a restricted type of good, a client receives a purchase order from a Russian entity for the supply of goods from the UK into Russia. And the question which has been posed is, does that export of the goods, does that create a risk of non-compliance with UK trade sanctions? And in that situation, Lisa, what do we have to do? What are we looking at?
So energy-related goods are identified by their commodity codes. So as a starting point, we'd need to have the commodity codes for the goods to understand if they come within the energy-related goods category. If they come within the energy-related goods category, then the export of those goods to Russia will contravene UK sanctions and should not proceed.
Simple. And if we move on, we're going to another example of trade sanctions, iron and steel, Lisa.
Yes, so iron and steel products is another category of goods which is subject to trade sanctions. As with energy-related goods, we've listed one of the prohibitions in relation to iron and steel products as an example on the slide. So Regulation 46D subparagraph 2 prohibits the import of iron and steel products which originate in Russia. And I think the key point to note here is that this prohibition would extend to the situation where the goods are purchased from a third country and imported into the UK, but where those goods originated in Russia. And Paul, on the next slide, we've got an example of how this has arisen for clients.
That's right. And that point you make around needing to look back to the very origin is the key, isn't it, here? So what we've seen is a number of scenarios where clients are looking to source steel for projects in the UK, and on the face of it, the supplier of the steel is going to be another entity or business that's operating or based or headquartered in Europe and in the EU. So there may not appear to be an issue there, but we're all very much alive to the importance of tracing back steel to its source. So what Lisa, should we be looking at there?
So I think as a starting point, we'd need to identify the ultimate beneficial owner of the European supplier, because as a starting point, we'd want to rule out the application of UK financial sanctions, whether that's by virtue of the European supplier itself being a designated person or because it's owned or controlled by a designated person. But once we've cleared financial sanctions, we can move on to look at the trade sanctions aspect. And as you say, Paul, the key question here is the country of origin of the steel. And that's because, as we've seen, the prohibition applies not just to iron and steel products which are consigned from Russia, but also to the import into the UK of iron and steel products which originated in Russia. And so if it transpires that Russia is the country of origin of the steel, then the prohibition will apply and an alternative supplier should be identified.
Great. So we'll look at licenses next, and this follows on from the discussion we've just had on trade sanctions and the important point that under the Russia regulations, Regulation 65, it's possible that prohibitions in relation to trade do not apply to anything done under the authority of a license here. So it then suggests that a trade license can be used or can be obtained to authorise conduct or authorise activity which will otherwise be a contravention of the trade sanctions prohibitions. Applications for trade licenses are administered by the ECJU within the Department for International Trade. It's a part of the ECJU is a group or a part of government that we've dealt with on a number of occasions. They are accessible. They do communicate. They've certainly had times they've been under pressure, understandably, in recent times. Although even, I suppose, at the peak of the height of demand in terms of new sanctions being imposed, we were still getting communications and correspondence from ECJU about existing applications for licenses. So they are there to help and to support. Different types of licenses are required depending on the different categories of trade. Prohibition, that's probably another seminar or webinar in itself. We won't get into that in tremendous detail today, but the principle is there that licenses can be applied for to authorise activity. So Lisa, probably a bit more straightforward this time, but when we're thinking about trade licenses, what are the thoughts for clients there?
Yeah, so I think as a starting point, we need to understand if the supply will come within one of the categories of restricted goods, and if so, whether any of the trade sanctions prohibitions apply, and which prohibitions apply, because the prohibition which applies is the starting point for identifying what type of license is required. So once we've identified that that a prohibition applies, we've identified which prohibition applies, we can identify the type of license and look to Regulation 65 to identify if an application can be submitted for a license in those circumstances.
Great. So just as we're moving on, I'll just pause at this point to say I can see that we've got a couple of questions that came through so far in the Q&A bar. Please do keep the questions coming in, and we'll look to get through a few of those at the end of the session. Lisa, so I'll pass back to you to move on to, I think, OFSI.
Yes, so in terms of the enforcement of sanctions breaches, the Office of Financial Sanctions Implementation, or OFSI, is the key regulator. It has responsibility for monitoring compliance with financial sanctions and for assessing suspected breaches. Where OFSI has identified a potential sanctions compliance breach, it has a number of powers. It can issue a warning, it can refer a regulated professional to the relevant professional regulator, it can impose a financial penalty. That's a civil financial penalty, which we'll come on to talk about shortly. Alternatively, it can make a reference to a specialist law enforcement agency for criminal investigation and potential prosecution. So moving on to look at the criminal penalties, which can follow on from a sanctions compliance breach in a little bit more detail. Of course, breaches of financial sanctions and trade sanctions are criminal offences, and we've listed the key penalties on the slide there. I think it's fair to say that any breach of a sanctions prohibition would likely be prosecuted on indictment. That's the more serious form of criminal process, which of course, as you'll see from the penalties listed on the slide, opens the door to the more serious penalties of imprisonment in the case of individuals and unlimited fines, both in the case of individuals and corporate entities. So looking at civil penalties now, before we move on to close the session with some practical compliance tips, I just wanted to say a little bit more about monetary penalties and the benefits of self-reporting. As I mentioned previously, OFSI has the power to impose a financial penalty as an alternative to prosecution. In that scenario, OFSI has the power to impose a civil penalty of up to £1 million or £1 million or 50% of the value of the breach. And the value of the breach is determined by reference to the value of funds which were applied in breach of the financial sanctions prohibition. However, there are opportunities for the level of the penalty to be adjusted downwards where there are mitigating circumstances or where a self-report is made to Ofsted. And provided the report is truly a self-report, i.e. it's not prompted in any way by Ofsted, and provided that it's made at an early stage and gives a full account of the breach, Ofsted has the power to reduce the headline penalty by up to 50%. So in addition to saving on management time in responding to and dealing with an investigation and potential subsequent prosecution, early and comprehensive self-reporting is potentially a valuable option for a business which has identified concerns about a potential sanctions compliance failure. And now we're going to give some just practical tips on how to manage the risk of a sanctions compliance failure. So as a starting point, I think the priority is to review existing relationships and take action if a counterparty or a business partner or a member of the supply chain is listed as a designated person or is owned or controlled by a designated person. Going forwards, in terms of new supplier take-on, it's important to carry out effective due diligence to be comfortable that new suppliers, new counterparties, business partners are not listed as designated persons, and also that they're not owned or controlled by designated persons. We also recommend that clients consider amending standard contracts to include warranties to the effect that the counterparty or business partner is not subject to any relevant sanctions regime, and also to provide clients with an express power to terminate the contract immediately if the business partner or counterparty is made subject to a relevant sanctions regime. Another key consideration is internal compliance policies, procedures, and risk assessments, and to make sure that these are updated to capture the business's policies, expectations, and procedures in connection with sanctions compliance. Related to that, it's important to provide training to staff on the impact of sanctions regimes, what the business's internal policies and procedures mean for staff, and the business's expectations in that regard. And finally, really important to identify a senior member of staff who has responsibility for monitoring compliance with sanctions requirements.
Great, thanks, Lisa. We're on to questions, but I wonder if we can go back to the last slide, because one of the first questions which has come in, I think ties in with the first couple of points on this slide. So the points around reviewing existing relationships to check on designated persons, and also to make sure that when you're onboarding new suppliers, etc., there's effective due diligence. The question that's came in on the Q&A is, how often should we review arrangements with businesses we deal with? So Lisa, on that point of once you've carried out your checks on whether it's existing business partners or new business partners you're bringing on board, once you've carried out your checks, let's say 1st of September, how often do you need to go back and reflect or review the position, given how dynamic the situation is right now with sanctions?
Sure. So as you say, we are in a very dynamic environment at the moment. We're seeing changes being made to the UK financial sanctions list regularly, sometimes on a daily basis. And I think in those circumstances, if you have your first check on the 1st of September, as we mentioned, on ongoing monitoring and having a procedure in place for ongoing monitoring will be a really important thing to be able to show a regulator if the need arises in due course. So I think if the first assessment is performed on the 1st of September, I would be thinking potentially every 2 to 3 months for a review, given how dynamic the situation is.
Yeah, I think I agree with that completely. I think that's been our experience since February into March, where the immediate action we took to support various clients to make sure they were content with their relationships. Again, we've had to review that after every 3 months since then, really, to make sure that nothing is being missed. And of course, I know that, Lisa, you've also on the slides we'd made a link to, or put a link to, the Ofsted pages, and again, very important to monitor. If you don't have an external provider who's doing that job for you, very important to monitor the updates to designated persons that are being pronounced by Ofsted, still on a fairly regular basis at this stage. Next, Lisa, slightly different question, but turning back to the trade sanctions side of things, we talked about the iron and steel controls and the prohibition on iron and steel that originates from Russia. So the question that's come in is there a duty of care to know the country of origin of all raw materials in the manufacture of iron and steel? So I think what we're looking at there is the idea of taking it back to the constituent elements which are then used to make the iron and steel, and whether we need to know the origin for those constituent parts. That's a slightly tricky one, but have you got a thought on that at the moment?
Not a situation that we've come across in practice. I think I'd probably need to give that some thoughts and look at the specific wording of the prohibitions. I suppose for the example that we had on the slide, we were looking at the import into the UK of iron and steel, which originated in Russia. So it's not immediately obvious that it would be necessary to trace back to the raw materials, but one I think we might need to take offline and give some further consideration to.
Okay, we'll have to do that. Another, probably more a comment than a question at this stage, which I completely agree with, which is around automation and the point that there are platforms and systems that will automatically monitor parties for their status on designated persons list, and I agree with that. There's a number of platforms that can be used. So if you have an existing set of customers or suppliers, and you know who your parties are, who you're dealing with, there's easy checks to set up to make sure that those people or the people controlling those businesses are not appearing on sanctions lists. So that's an option to have that automation. I think the key there is, again, to know, not just know the immediate customer or entity you're dealing with, but again, as we discussed earlier, to make sure that you know about the ownership and control going up the chain to the top of that business. Another question, Lisa, I think we may have covered this one possibly to an extent earlier on in the presentation, which is what sanctions compliance steps should we take before entering into a JV arrangement? So possibly we've covered that to an extent, but do you want to just quickly go back over that point?
Yeah, as you say, I think we've covered it, but I suppose starting point is the principal financial sanctions prohibitions that we looked at at the beginning of the session. So starting point is the joint venture partner itself a designated entity. Then we need to be looking behind the joint venture partner to understand whether it's owned or controlled by a designated person. Then we come on to the joint venture prohibition itself, and that's all around understanding whether there are connections with Russia. So in relation to the entity, it's about the incorporation or place of business of the entity, and in relation to individuals, it's whether they are located or resident in Russia. I think when we've this situation has come up in practice, actually, we've got some very helpful information from Companies House, where we've been able to identify that the individual board of directors of the joint venture party, according to information on Companies House, are resident in the UK. So that's a helpful way of verifying the location of the key individuals there.
Great. There's a number of questions that are all overlapping on this, if you like, 50% threshold for ownership and control under financial sanctions. So to remind everyone, we looked at this earlier in the session, it's this idea of, yes, your immediate counterparty may not be a designated person, but is it owned or controlled by a designated person? And you have one part of that test is the 50% part, which is the 50% ownership of that entity by the designated person. So almost having that effect of ownership and control. Now, there's a few other points to that, but I won't bog us down too much. The first question on that, Lisa, is what happens if you're in a situation where the ownership by the designated person is sub 50%? So, for example, if it's 42% or 46%, you're not strictly speaking. And there are a couple of other questions which I'm going to come on to in a second, which are also tied with this. But let's start with that in principle point. If it's sub 50% ownership or control, so not an immediate designated person controls or owns, what should you be thinking about there if you're dealing with that business around de facto control or other arrangements by which the designated person actually does have control? What are the thoughts for a business in those circumstances?
Yeah, so of course, I mean, Regulation 7 gives us the legal test, the 50% threshold test, and we've seen this situation arise in practice quite frequently, where we're looking at a parent which has sub 50% but close to 50%, and there's a sort of slight feeling of discomfort about how close we are to that 50% threshold. I think then it comes down to what the business is comfortable with, what the broader industry position is, and I suppose also the reputational aspects around continuing to do business with an entity where we're seeing control close to the threshold, but not at or above it. I suppose also in relation to the control side of things, we have had a number of situations for clients where we haven't seen the 50% threshold met in relation to voting rights or an ability to appoint or remove a majority of the board of directors, but where open source information has given us a sense in relation to that final part of the test that there is an overall ability to control matters. So it's that kind of catch-all bit at the end of the control test that we need to be aware of.
Great. And another point, which again related to this 50% issue, but slightly different, one other question that's came in is the idea that the ownership or control is from a Russian parent. The Russian parent is not designated itself, but because of banking facility arrangements, there's been the banks have effectively determined as a matter of contract that the client can't engage with that counterparty. Again, I think we've seen that on a few occasions where the commercial requirements, the facility requirements for the bank go above and beyond what strictly is the law in terms of designated persons. But do you have a practical view, Lisa, on how to approach that at this stage? I mean, obviously the bank's terms and conditions, if you signed up to those, you're tied to those to an extent. There's a limit to what you can do around that, and it probably becomes more a matter of the commercial agreement with the bank than strictly compliance with sanctions regulations, possibly.
Yeah, I think this is something that we've seen with banks, but also with insurers. And then I think really it becomes a contractual negotiation around what the bank is prepared to lend on, and what the insurer is prepared to provide insurance on. So I think in practical terms, it might be worth a discussion with the bank and the insurer to guide them on the terms of the regulations, but whether or not they're prepared to move from their contractual position, well, I think that will come down to individual discussions.
Sure. I mean, there's quite a lot that could be said. I'm not going to. I'm sort of biting my tongue a little bit because there's quite a lot that can be said about the consolidating or reducing designated persons into discussions about Russia and the oversimplification. And we've seen that in a few settings and forums as well. And I think it's really important to actually be clear on what the legal requirements are in the first instance, and then start from there. And but yes, as you say, Lisa, by all means, if there's a reputational decision to be made, that's great, but make the decision either for legal reasons or reputational reasons or whatever the reasons are, and be clear about your decision-making process rather than it all being balled up together, which I think is sometimes the risk that we see. There's a whole stack of questions coming in. I suspect we're not going to get through all of them. I'm going to keep going for a little bit longer. The next question, which I'm looking at, it's the crystal ball gazing piece now, Lisa, which is it anticipated that there'll be further prohibitions or restrictions in the near future, or perhaps will restrictions be reduced because of the supply chain interruptions worldwide that we're seeing right now? That's not really a legal question at all, is it? It's much more a political question, but can you give that swing at that one and see what you think?
Yeah, so I mean, I think we've in July we had a whole raft of new prohibitions introduced, which were trailed back in May. So big amendments came in July. My guess is that if anything, we will see an increase in prohibitions rather than a decrease, given that the fact that the intervention doesn't appear to be to be coming to an end anytime soon. So I would be plumping for a broadening of the scope rather than a reduction of it.
Yeah. So what if we were being really clever? What we'd do is I would now say the opposite. I would say restrictions in the near future, and then we could just have 2 edits of the webinar, and we could just put out whichever one turned out in 6 months to be correct. But we're not that sophisticated, unfortunately. Next, then, going back to this point around the use of technology. And I have this next question I've got a lot of sympathy with, because we've seen this before. So when you're ascertaining whether someone is designated, and if you have a platform, for example, Dow Jones is one of the platforms that's been identified, other platforms are available, and many hits arise for that person, how do you verify whether or not that's actually the designated person? So I would say that the starting point there is, if once you've got that automated, if you like, trigger, then it really is down to the business to find out more about the person they're dealing with, and understand if the person they're dealing with is the person who's showing up with multiple hits. So it's really about you doing more, unfortunately, manual investigation to understand if who you're dealing with is the same person who appears on the alerts that you're seeing. Lisa, do you have any other thoughts on that one?
Yeah, the only thing I would add is just picking up on the helpful guidance available from OFSI. There's guidance from OFSI on how to deal with this. So for instance, if you have a match on the second name but not the first name, or a close match on names but not maybe a complete match, there's some guidance on how to deal with that available from OFSI, which is very helpful. But yeah, absolutely, I agree. It's more the investigation side of things, as you were saying, Paul.
Great. Do we have a link to the OFSI guidance on the slides? Because if not, when we send out the webinar afterwards to everyone, we'll make sure that we attach a link to the OFSI guidance.
Yeah, I think it'd be helpful to attach a link to the specific guidance on financial sanctions in relation to Russia, so we can make sure that we circulate that after the webinar.
We'll do that. Great. Okay. I did want to, I'm conscious of time, and we were scheduled to stop at 1:45 the hour. There's quite a few questions still there. What we'll do is Lisa and I, with the remaining questions, we'll filter those out and we'll respond directly, because I think we may run on a little bit too long if we keep going through the questions that are coming in right now. But so I'll stop there on questions. I wanted to thank everyone for attending this morning, for your attention. As usual, we can see the numbers of people who are here, and it's great to see that everyone stayed with us all the way through the session. That's been much appreciated. Thanks for your questions also. Thanks for your interest in the subject. A big thanks to you, Lisa, for all of your hard work in preparing the session with me. I really enjoyed doing that with you today. I need to let everyone know about the next Academy event. It's on the 28th of September. It's in the office in Aberdeen, which will be fantastic to have people back together again. The subject is current trends and developments in the energy sector. If you keep an eye out on the website and through your usual Brodie's channels, you'll find out more information about that event. But if it's an 8:30 start in the morning, there must be bacon rolls in Aberdeen. That's what I'd assume will be happening there. So that's all for us. From us, there will be a survey which will be put out to you after this session. Please do take the time to respond to that. You've also got Lisa and I's details here if you've got any follow-up questions, or it'd be helpful to speak to us. But that being the case, thank you all, and goodbye for now.
Thanks all. Bye for now.